Well, joining me now, Joyce Vance, former U.S. attorney, now law professor at University of Alabama, MSNBC legal analyst and host of the Sisters-in-Law podcast, and Hugo Lowell, senior political correspondent with The Guardian. Welcome to you both, my good friends. So, Joyce, are Trump supporters already responding to his retribution clarion call?
You know, the problem with this, Alex, is that there's appropriate response and inappropriate response. Political advocacy, always appropriate in this country. But you never know when someone on the fringe will be motivated to violence by some of these words. And that's the real risk prosecutors are trying to avoid by keeping the gag order in place and hopefully imposing some concern for consequences, like the potential for incarceration on behalf of the former president.
Okay, and to that point, in the hush money case, the Manhattan DA says that online threats include a post depicting sniper sights on the DA and people involved in the case, as well as posts using words like, "We will kill you," kill all, and saying people who remain unnamed in the filing should be in witness protection. So, Joyce, can any of this impact Trump's sentencing on July 11th?
It absolutely can. New York has indeterminate sentencing for nonviolent crimes like this. The real issue in Trump's case is whether he'll receive a sentence of probation or a sentence of custody. And sentences of probation are typically reserved for people where the judge believes that they can comply with all of the conditions of release. So this plays with whether the gag order will remain in place and what other conditions might be involved in a probationary sentence. In other words, if you're Donald Trump and you're playing it smart, this is not the time to continue to threaten people.
Okay, so Hugo, I want to play a former Trump White House staffer talking about retribution and what she witnessed in the Oval Office. Let's watch this.
About a meeting he and I were both in the Oval Office where Trump straight up said a staffer who leaked a story should be executed. And Bill Barr kind of danced, said, like, I don't recall that specific instance, but there were others where he talked about executing people.
And look, Alyssa Farah-Griffin says that this came out more than once. So this is not mental flatulence. I mean, Trump has given it serious thought. Can a sitting president with a willing attorney general put this in motion?
It will be interesting to see, right? I mean, we have seen and reported on Trump and his allies trying to come up with what he wants to accomplish in the second term vis-a-vis going after the people that came after him. And in the event that Trump installs as Attorney General someone who is sympathetic, someone who is loyal, and Trump can just call up Justice Department and say, hey, I want you to go prosecute these guys, I think that's very possible. I also see and envision a scenario where Trump goes, not only do we want to prosecute them, but we want to go after them and make their life miserable, whether it's through the IRS, we know that Trump, in the Trump years, the IRS went after his political enemies. I can see that happening as well. This is the sort of thing that is discussed a lot inside Trump world as we get closer to the election. And I think everyone should just take it at face value.
Okay. So, Joyce, what is the impact of the Supreme Court's delay on the Trump immunity ruling and resulting delay in his D.C. January 6th trial? Does it benefit him politically? And is that something justices would or should consider?
It benefits him politically and legally for all of the obvious reasons. There won't be a trial before the election, and that has impacts in both sort of spheres that he's operating in here. It's never appropriate for justices to rule on cases on the basis of information that doesn't involve the facts and the law in that case. But by the same token, it's not appropriate for a court to delay its ruling unnecessarily. And here there's a very fine line. There's a tradition on the Supreme Court. Every justice gets the time that they need to write their own opinion. So you can easily imagine a scenario here where there are a number of dissents and concurrences that are being drafted, and those justices are entitled to take their time. But for heaven's sakes, I mean, this is a situation where the case was well briefed before it went to the court. And this notion that the delay doesn't have consequences in this particular instance, that the delay itself becomes something that it's inappropriate for the court to engage in, is really difficult to shake at this point.
This is interesting, Joyce, because Politico is reporting on a rift in the Supreme Court, saying Justices Clarence Thomas and Amy Coney Barrett may be at odds over the extent that originalism should influence modern issues. Could this be what is holding up the immunity decision?
You know, possibly. I suspect that this plays less in the immunity case than it does, for instance, in Rahimi, the gun case that was decided yesterday. And I'm not sure if it's really a rift, because Rahimi was an 8-1 decision. Only Justice Thomas took this absolutist view of Second Amendment jurisprudence and said we were bound by what the Founding Fathers believed, or what Justice Thomas believed the Founding Fathers had in mind when the Constitution was written. I think the problems in the immunity case are in some ways very practical. Most legal scholars agree that there has to be some scope of immunity for presidents who are acting in good faith on the basis of information provided by legal and other observers when they're in a time-bound situation, when they've got to make a snap decision. But by the same token, it's very clear that presidents shouldn't have immunity when they engage in insurrections or try to overturn an election. And so if you believe, and Justice Gorsuch, in fact, made this point in Rahimi yesterday, that the court should only decide the issue in front of it, it doesn't have to, as Justice Kavanaugh said at oral argument for the immunity case, make decisions that are sweeping, declarations for all time. Courts are really supposed to decide just the issue in front of them. And so this court can make a decision about the scope of immunity and simply say, this isn't it. We'll leave for future cases where there might be a dividing line, but we know that a president who tries to overturn an election shouldn't have immunity.
Okay, so here are the options, Hugo. Justices can either find Trump has no immunity or that he has absolute immunity, or they could split that decision and let Judge Chutkan decide which of his January 6 actions were done in an official capacity. Either way, though, the ruling should come by the first week in July. So is it likely the D.C. trial will then start before the election? There's no question as to whether it will be concluded by the election, but at least start?
That's a really interesting question, because it depends on how the Supreme Court writes its opinion and how it remands the case back to the lower court. I think we should expect there to be some sort of remand with instructions for a lower court to go through the indictment and take out elements that are clearly things that are protected by official immunity. Things like the president's ability to fire the attorney general, him threatening to fire the attorney general. Trump's lawyers will argue that was within the gift of the presidency and that should be taken out of the indictment. Michael Dreeben, when he argued before the Supreme Court on behalf of the special counsel's office, even conceded that there should be some official immunity. So I think that is almost certain to happen. The question is how long this process takes to go through the indictment and strike out kind of potential parts that infringe on official immunity. That could take weeks, and it really depends on whether we have to go line by line, whether it's going to be evidentiary hearings. I will say the Justice Department appears to be of the opinion that if this is particularly expedited and it goes back to Judge Chutkan, who has been relishing to get back on this case in many respects, then there is a scenario where a trial could start in September. That's kind of what the Justice Department is thinking, kind of as recently as this week.
Okay. One more quick question to you, Hugo, because you're there in Florida covering Trump's classified documents case. Judge Cannon is hearing 5 pretrial motions over 3 days, including hearing oral arguments from people not connected with the case. And you have an exclusive report on one of those hearings. What is going on there?
Yeah, so the majority of these hearings yesterday and through the next week is to do with the appointment of Jack Smith as special counsel and whether that was done unlawfully. Our reporting is for the Tuesday hearing, which is going to be conducted under seal. And it's to do with what Trump's lawyers are saying was the improper application of the crime fraud exception onto one of Trump's ex-lawyers' notes. And the reason why this is significant is because the notes form a key part of the obstruction case in the classified documents prosecution. If you go back to the indictment, you will recall that the Justice Department put all these things in about how Trump was, asking his lawyer, Evan Corcoran, whether he could pluck certain documents out of what he was going to return to the government, or whether he even had to comply with the subpoena. And that, I think, forms really important evidence of Trump's potentially obstructive intent. If Judge Cannon grants this motion, even in part, or grants what Trump's lawyers are asking, which is to exclude all of these notes completely, that could well severely undercut the obstruction part of the case. I think that's really significant.
Okay. Hugo Lowell, Joyce Vance, thank you both so very much.